Guys, welcome to part 13 of our video series on the text of the Fair Debt Collection Practices Act. And in a sense, everything that we've looked at in the previous 12 videos has been building to this point. So we've been talking about what is a debt collector, what debts are covered, what are ways that debt collectors violate the law. And ultimately, we get to the question, so what? So what that they violated the law? Well, this is the so what. This section 1692K, civil liability. So this is where we'll talk about when can we sue a debt collector? What can we get when we sue a debt collector? Do they have any defenses if they admittedly broke the law? And what about individual cases, class action cases? And so we'll cover all that in this section. So we start off in subsection A, amount of damages. Except as otherwise provided by this section, any debt collector who fails to comply with any provision of this subchapter with respect to any person is liable to such person an amount equal to the sum of, so it's going to be the total of what we're talking about. So then we go to subsection 1, any actual damage sustained by such person as a result of such failure. So in this statute, it's called actual damages. In a personal injury context, we more commonly call these compensatory damages. The idea is to compensate you. So it's easier to think about in terms of, say, a car wreck. If you are hit by a car, somebody runs a red light, hits you in your car, and you have $10,000 of medical bills. And let's imagine you had no pain. Obviously, this is not true, but you had no pain, no limitation, 10,000 medical bills. Well, your damages would be $10,000. Because right before you were hit, you didn't have that $10,000 in medical bills, and right after you hit, you were going to incur those medical bills. So $10,000 would compensate you, would bring you back to even, so to speak. Now, in a car wreck case, we also are going to have pain and suffering that a jury will have to decide what that amount is. You might have lost wages, all sorts of things. You might have a permanent impairment. Maybe your leg is never quite right, or your elbow is never quite right after the wreck, or maybe you're paralyzed. So in a FDCPA case, we have the same thing. We go, all right, what are the actual damages that you've suffered? Now, it could be they continue to call your work after you tell them you're not allowed to get these calls, and your work fires you. And you had a $75,000 a year job, and now you're only able to make $35,000. Well, you'd have $40,000 a year in damages because of that. Now, it gets a little more complicated. We have to take into account taxes and present value and all that sort of stuff. But the point is, we look and say, but for this debt collector violating the law, what would have happened? Well, if they had not done this, I wouldn't have been fired. Or maybe they put something bogus on your credit report, and as you refinance your house, instead of getting 4.5%, you get 7%. Well, that interest rate spread, we'll look at that over the life of the loan, and again, bring it back to present value and say, this is the damage. This is the out-of-pocket. We're not talking about any pain and anguish, mental suffering, emotional distress. We're just talking about numbers we can write up on a whiteboard, okay? So we look at that. Did you lose a job? Did you have a higher interest rate? Did a debt collector foreclose on your house when they had no right to? And you were making $1,500 a month house payments, and now to be in the same school district, etc., you're paying $2,500 in rent. Well, again, we would look at all that. And with the FDCPA, we also can get emotional distress or mental anguish. So this debt collector is harassing you. Maybe they're cussing you. Maybe they're making racial slurs, whatever they're doing, and that causes you to be upset. Well, there's a value on that a jury has to decide. So all of that is encompassed in this subsection 1, any actual damage. Then we go to subsection 2, and it says in Part A, okay, if we're talking about an individual, such additional damages as a court may allow, but not exceeding $1,000. So these are what are called statutory damages. So it has nothing to do with you being hurt. It's just the court can say, because this debt collector violated this law, I'm going to impose, or the jury's going to impose, up to an additional $1,000. Now, in other federal consumer statutes, sometimes we can stack these statutory damages. So if you're familiar with the TCPA, Telephone Consumer Protection Act, we've had cases where people might have 300 illegal robodial calls to their cell phone. Well, that's $500 a pop, and it can be up to $1,500 a pop. So we say, okay, 300 violations at $1,500. If my math is right, that's $450,000 in statutory damage. With the FDCPA, it's just $1,000 total. Now, there's some discrepancy among courts. Is that $1,000 per defendant or just $1,000 for the whole lawsuit? But the point is, you don't stack these damages up just because there's another violation. Now, if we go to subsection B, it switches the focus to class action. And it says, if you look at this little I, okay, such amount for each named plaintiff as could be recovered under paragraph A. In other words, that's actual damages. And then double I, such amount as court may allow for all other class members without regard, not to exceed the lesser of $500,000 or 1% net worth. So as a practical matter, when we do class actions, it's very difficult to get actual damages. Now, sometimes you can, but often those actual damages are so individualized. In other words, we'd have to bring every class member in, put them under oath, and say, okay, let's figure out your actual damages. So typically, not always, but I'm going to say 99% of the time, when we do a class action, we're talking about statutory damages. So the most you can recover is $500,000 or 1%, whichever is less. So it's going to be, $500,000 is your absolute maximum. But if 1% of the net worth of the collector is $50,000, well, then that's all you can get in a class action. So class actions are not real appealing here, particularly when people do them nationwide. And you might have, 100,000 class members. Well, the most you could get for them is $5 per person, but you're taking away their right. So I'm not a big fan of FDCPA class actions unless they're really, really focused. Maybe it's everybody in your state or everybody in your city or everybody in your county. And so we're not trying to wipe out everybody's rights for some relatively small amount of money. Okay, so then we go to the subsection 3. In the case of any successful action to enforce the foregoing liability, the cost of the action. So costs tend to be your filing fee. It costs you $500 to file the case or whatever it is. And then certain of your expenses that are incurred as you're prosecuting that case. So certain deposition cost, or maybe you have to fly to New York to take the deposition of the debt collector, or you got to go out to Virginia to depose portfolio recovery, whoever it might be. Those types of things tend to get rolled into the cost. And so the idea is whatever you legitimately had to spend on this case to get to the end result, which is being successful, then you may be able to recover that. And then it says, together with a reasonable attorney's fee as determined by the court. And so this is where, people who do this type of work will often say, well, you can get a free lawyer. In the sense of you don't have to pay your lawyer. The court's going to order the debt collector to pay your lawyer. Now, I'll say this. A lot of times in settlement, the rule is, and there are exceptions, but just the rule as a matter of practice is there's a settlement without the judge deciding what your attorneys are going to be awarded. But you do have this possibility, even in a settlement, of saying, well, we'll leave it up to the judge to decide the amount of the attorney's fees. So it's really nice because the debt collector that breaks the law, when it gets sued, it has to go through this thought process to say, okay, I know we did something wrong. I know we're going to get hit for actual damages. I know we're going to get hit for up to 1,000 statutory. We're going to have to pay our attorneys, and we got to pay their attorneys, the consumer's attorney. And so it really makes them think about, do you really want to fight this? You want to fight this to the death? You want to make everybody spend a bunch of time and money? Because ultimately it costs the debt collector if they lose the case. And then sort of the flip side of this is the last part of this paragraph. On a finding by the court, the action was brought in bad faith and for the purpose of harassment, the court may award to the defendant attorney's fees reasonable in relation to the work expended and costs. And so what they're saying is, if you bring a bogus FDCPA case, then you may end up having to pay the defendant's attorney's fees and the defendant's costs. Okay, now let's look here at, these are factors when looking at that statutory damages. So $1,000 max for individual, $500,000 max for a class action. It says court shall consider among other relevant factors. So it's not just saying this, but giving a court a list of things to look at here. The frequency and persistence of noncompliance, the nature of such noncompliance, and the extent to which such noncompliance was intentional. So that's subsection 1. And so what this means is when you're in a lawsuit, you're entitled to know about other acts of noncompliance. Now, the debt collectors just have a complete come apart when you ask about that. Like, oh, that's absolutely not relevant. We go, yeah, because the court has to look at, hey, what's going on here? Are you doing this to other people? And so the way that they'll try and get around that is they'll say, well, we'll agree that if statutory damages are awarded, they should be $1,000. Or they'll say, if we're liable, we agree to the full $1,000 statutory damage, which is clever. And, it doesn't matter to me because it's a guaranteed $1,000. So, we'll take that for our client. But then look at the subsection 2, class action, frequency, persistence, nature, the resources of the debt collector, number of persons affected. In other words, was this typically the minimum for a class action is about 40. So was this 40 people, or was it 400 or 4,000 or 4 million? What was it? And the extent to which the debt collector's noncompliance was intentional. So we've been talking about this idea of intent. And so it flows naturally that the very next subsection is entitled intent. And this is what is known as the bona fide error. So let me just describe this to you and then we'll read it. Bona fide error is where a debt collector says, okay, you caught me. I broke the law, but it was not intentional. And I had procedures in place that were designed to avoid this specific error, whatever it is. Maybe you file bankruptcy and they still are calling you, which they shouldn't because there's something called the automatic stay that protects you. Or they're trying to collect a discharged debt. Or you've already settled, they're trying to collect the debt again. Well, they say, well, we've analyzed where all the possible errors could be in our business of collecting debts, and we've created these procedures, and we enforce these procedures to make sure those don't happen. And it still happened, but it was totally unintentional. Then the court says they get off the hook. So you could think of this almost like negligence. So normally when we're dealing with a tort, which is a state law claim where somebody's done something wrong and harmed you, the plaintiff, the one suing, the consumer, has to prove that the other side was reckless or negligent or careless or broke a safety rule in order to establish liability under negligence or wantonness or recklessness. And here it's kind of reversed. So if they break the law, that's it, they're liable. And then the debt collector has to come in and prove, so not the consumer proving, but the debt collector proving, what we call the burden of proof. They have to prove that this was just an accident and they had carefully designed procedures to avoid it, but it still happened. So it kind of flips the burden of proof from the plaintiff to the defendant. So let's look at it. It says a debt collector may not be held liable in any action brought under this subchapter if the debt collector shows by preponderance of evidence. That's our standard in civil cases. It's not beyond a reasonable doubt. It's if you have sort of the scales of justice and it slightly tips one way, well, that's preponderance of evidence. If you think about it in terms of percentages, if it's 50-50, then that's not preponderance of the evidence. But if it's 50.1% likely, then that's preponderance of the evidence. So it's saying shows by preponderance of evidence that the violation was not intentional. So if they do something intentional, we're not even thinking about bona fide error because it wasn't an error. It was intentional. So if they say, hey, you know what, we're going to call your work, we're going to call your family members, we're going to call your preacher, we're going to call your neighbors, and we're going to terrorize you until you pay the, well, that's not unintentional. Okay, that instead is intentional. And I think even something that we pull back from that, and let's say they've written you a letter that says, if you pay us $5,000, this debt's settled, you owe us no more. You pay them $5,000, and then they start collecting. And I've talked about this in other videos where I don't know if they've been released or not, but where you call them and say, hey, you still have that on my credit report showing that I owe this money. And they go, we don't believe you. You go, well, you wrote me a letter. We don't believe you. Well, to me, that is intentional. Because if they were truly concerned about this, they would say, well, let me go check our records or fax us a copy of the letter. So the point is, to even remotely be in the ballgame of bona fide error, they have to show that it was completely unintentional. And then going on with this, and resulted from a bona fide error, notwithstanding the maintenance of procedures reasonably adapted to avoid any such error. So here's what debt collectors in the past, and some still do, they say, well, any violations of bona fide error, you go, okay, what's your procedure? They say, well, we have in our policy manual, don't violate the FDCPA. It's like, okay, that is way too clever, okay? That proves nothing here. It has to be the specific error that you have these procedures in place for. You can't just say, hey guys, don't violate there. It'd be like a trucking company saying, well, hey, we shouldn't be held liable when our truck driver causes a wreck because we have a procedure that says don't cause wrecks or don't violate the rules of the road. Like, well, you got to be a little more specific than that. So when let's take an example of they sue you, you win your case, and they sue you again. And we've had this before. By the way, those are incredible lawsuits against the debt collector. So much fun to do those. And so they've sued you, you won, you owe no more debt, you don't owe them anything, and they sue you again. And they go, oh, well, that's bona fide error. We say, okay, well, what's a bona fide error? They say, well, we have a procedure that says don't sue somebody when you're not legally entitled to sue them. Well, that's so generic that it means nothing. And when you press them, they say, well, this didn't get coded right. What do you mean it didn't get coded right? Well, you're supposed to hit F5, and this new employee hit F6, and so we thought we could sue again. You say, well, now you know that it's possible an employee, if it's that easy, if hitting F6 instead of F5 means somebody can get sued twice on the same debt when they've already won the case, then you should have a procedure that says, okay, just because somebody hit a certain key on the keyboard, we still have to go back and check this. Like, we know that we've sued Joe Blow. And even though it says we can sue him again, maybe we need to have somebody manually look at that. They go, oh, no. We just have procedures that say don't sue when you're not entitled to. Well, that's not going to be bona fide error. So the courts have been pretty consistent on this, that as a debt collector, you've got to have procedures in place that are designed for this particular error, not just errors in general. And you've got to show that you actually enforce those procedures. I mean, go back to a trucking example. You couldn't have a sign up, and by the way, in trucking cases, they don't get off the hook just because they have a procedure. I'm just using that as an example. Let's say they have a procedure that says never exceed the number of hours that you can drive, never drive drunk. And yet the supervisors and the owner of the company are in the truck as they're going 24 hours straight driving, and they've got heroin needles in their arms. Okay, well, obviously those procedures are not being enforced, okay? And so here, if a debt collector, they can have the most beautifully worded, most specific procedures in the world, but if they are not actually enforcing those, then they're meaningless. Okay, so now let's look at, we'll go through the last part here because I know this video is running pretty long here. Jurisdiction says you can bring it in an appropriate U.S. district court, so that's a federal trial court, without regard to the amount of controversy. So we did a video recently where we talk about jurisdiction, and so there's two ways to get into federal court. One is what's called diversity jurisdiction, and the amount has to be over 75, or federal question involving a federal statute. And this is just pointing out the amount in controversy doesn't matter because this is a federal claim, so you have the right to be in federal court or in any other court of competent jurisdiction, so that would be like a state court, within 1 year from the date on which a violation occurs. So it's a 1-year statute of limitation, pretty short. So you have to keep that in mind. And this last part is basically saying, look, if you do something in good faith, consistent with any advisory opinion of the Bureau, that would be the CFPB, notwithstanding that after such act or omission has occurred, such opinion is amended, rescinded, or determined by judicial or other authority be invalid. So it's saying, look, if the Bureau that regulates debt collectors says you can do X, and you do that in good faith reliance on what they're saying, and then after you do it, the Bureau or a court says, well, really, you shouldn't do X, this is saying you're not going to be liable. In other words, if you rely on what the government agency tells you you can do, then we're not going to punish you by saying, hey, you relied on them, but you're still at fault. So if the IRS would be an example, if they say you can take a certain tax deduction and you do it, and then later they go, oops, we were wrong on that, it's not like you go to prison for tax evasion because you relied on what they said. So I hope that this video is helpful to you. Again, this is what we're building up to, is looking at when does a debt collector violate the law. And so now they violated the law, what are you entitled to by way of damages? And the rest of the provisions, frankly, are not as important for us, but we'll finish them up just so we can, totally complete the FDCPA here. And as always, if you have any comments or questions, put those below. And thanks for watching this video. You have a great day. Bye.